It wasn't until Gitlow versus New York in 1925 that we saw the federal Constitution get applied to state laws. And this wasn't a First Amendment issue, this was actually a 14th Amendment issue, which is the Equal Protection Clause. And that comes out from the Civil War, some of those amendments that came out, 13, 14, 15. And that means that the federal government, the Constitution, applies to every state law. It supersedes those state laws in there. And in fact, we don't actually see the first Amendment case until 1918 when you're talking about the overthrow, and much like Gitlow here, you're talking about the overthrow of the government. At that time, you're talking about World War I, you're talking about communism growing, and these sorts of things. Gitlow's case, as we'll see, is a violent overthrow of the government, and the government being able to stop violent overthrows of the government. But it's not until we get into that kind of early 1920s that we really start seeing First Amendment rights tested. So for the first 120 years or so, we don't actually have a First Amendment case. So it's not until really the 20th century that the First Amendment's actually tested. Which brings us to, how do we actually test the First Amendment? The First Amendment really has two basic approaches: content-based and content-neutral. This is the key to pretty much the entire existence of the rest of the course that we're going to talk about, the First Amendment. Content-based or content-neutral. Is the law or regulation content-based or content-neutral? One of the important things to remember in all of this is that it's the government. The government can't do these things. That doesn't mean that there's not punishment for, if a private person says something, right? You can be in trouble for doing that. We call that like defamation if you're trying to harm their reputation. And we'll talk about that later. But this is the government, okay? The government can't stop you from saying things. Other people can. There are consequences for that. The First Amendment right does not give you the right to go tell your boss of Starbucks, to blank off, right? These are really for regulations about what the government stops you to do. So that is a big key in any of this. We're talking about government laws and regulations that stop speech or action. This brings us to the first kind of logical question. Is it content-based or is it content-neutral? If it's content-based, it needs to be about content. Is it subject matter or is it viewpoint? Subject matter means, does the government prohibit you from speaking about a certain subject? Pick a topic. Abortion, civil rights, social justice, whatever it is. If the government stops you from talking about that, then that is a subject matter based regulation. If it's viewpoint based, that means the government won't stop you on the topic, but stops you in a certain way. So it only allows for pro-life talk or pro-choice talk. It doesn't allow for the other side. In First Amendment law, whether you agree with it or not, the idea of marketplace of ideas, where every idea is valid and the top ideas kind of float to the surface, exist, which means you have to have the good and the bad. What you find, what you like, and what you detest have to have the same rights. But if the government stops you from doing that, either by just stopping you from talking about that topic in particular, or stopping you from talking about a specific position that you have, that becomes subject-based or content-based. Now, there's a little caveat that some of the states use to go around content-based rules. They would call them content-neutral rules, and content-neutral rules are legal. They have a different test, and we'll talk about that test in a minute, but content-neutral rules are time, place, and manner. Time, place, and manner. The government can regulate the time that you can talk about certain things. They can regulate the place that you talk about them. and they can regulate the manner that you talk about them. Right? A simple example of a content-neutral law would be music. Right? Maybe there is a sound ordinance that if you are at night between 10 p.m. and 6 a.m., you cannot have music blasting out of your house at 70 decibels being heard from the street, whatever those measurements are. It could be a school zone. It could be decibels in a school zone during a school day. Those are time, place, manner restrictions, right? They could also tell you that you can only be in a park from sunup to sundown. So if you're trying to have a protest in a park, same sort of thing, right? Those are content-neutral laws. Content-based laws look at what it means, what the content of the thing is. Content-neutral laws don't care what you're talking about. They just want you to do it in an organized way, right? And try to regulate you in an organized way. But as I said, there were some caveats. If a law is content-based on its face, it will be treated as content-based. If on its face it looks content-neutral, but they find out that it's really a content-based regulation, that somewhere in there the creation of this ordinance was really due to the fact that they wanted to prohibit a certain type of speech, then it gets treated as content-based. Of course, if it's content-neutral and in fact has a content-neutral purpose, it's treated as content-neutral. The idea behind making sure that we test the purpose of the law is to make sure that governments aren't creating regulations that look like they're only regulating certain things, but actually are discriminatory. So if you think of red lines, especially in housing, those are all things that were done that on their face look like they're non-discriminatory, but when you dig into them, they are very discriminatory. And the government has decided to, or the courts have decided to make sure that we look at the purpose of it to understand the difference between content-based rules and what they are and content-neutral rules and what they are. When it comes time for content-based, the test you see on your screen is what we look at. It's a compelling state interest, it's narrowly tailored to achieve its goal or interest, and it has the least restrictive means for achieving that interest. The compelling state interest is probably the most important part. That means the government has to have a compelling reason why they should regulate that sort of regulation. Compelling state interest means usually things like national security. It means things like public health. It has to be a damn good reason why the government should be allowed to do that. When it comes to testing, I like to use a stoplight. Red light, green light, and of course yellow light. Content-based is the red light in my example. Because strict scrutiny, the government almost always loses. It's really high on the burden of proof that the government needs to interfere with people's lives to regulate this in this area. Whereas opposed to we get into intermediate scrutiny, which is the next set we'll talk about, which is the yellow light, where there has to be an important interest, and then rational basis, which is the green light, and that means as long as they have a rational reason, if they can indict a ham sandwich sort of thing, right? Like they can, as long as there is a basis to make a regulation, they can do that under green light. But on this end, on the red light, they really have to have a reason, a compelling reason to regulate people's lives. And again, we talked about the gay marriage case. This is where strict scrutiny got applied. The government said, or the court said, the government has to have a really good reason to interfere on marriages, right? And what marriage means. And because of that, that's why the cases got, and the laws that were passed, especially in the 6th District, or in the 6th Court of Appeals, got overturned. The next thing we look at is narrowly tailored. Narrowly tailored means that it has to fit within the description of what it is that's going on. You can't just outright ban an entire piece or a section of it. You have to actually narrowly tailor it so that when you're trying to do it for that really damn good reason, that it's only that damn good reason that you're doing. And that, of course, also goes to narrowly tailored, or the least restrictive means as well. So narrowly tailored means that it's not just a broad up for interpretation, but is very descriptive of what it is that it's trying to regulate. And then least restrictive means that there's not another way of making sure that that information can't get out there. When it comes to content neutral, we're looking at intermediate scrutiny. Again, this is the yellow light. Here, instead of compelling state interest, what we see is an important state interest or a significant state interest. This means that the government just has to have an important reason. It can't just be whatever they want. It has to be an important reason, maybe education, maybe some more safety. Those are the things that the government's going to be looking for when it comes to important state interests. Again, narrowly tailored, substantially related are important, and in this one it also adds ample opportunities for communication. Right? There have to be other ways that the communication can come out. You might be able to restrict it one way, but you can't restrict it in every way. And so maybe it becomes instead of being over a megaphone, it becomes over handouts, whatever that means, right? Or vice versa. And so that's what intermediate scrutiny is. Now there's one oddball in all of this, and it's called the secondary effects doctrine. This doctrine got created in 1976 in a case called Young versus American Mini Theaters. Again, this is kind of it happened in Detroit, that really allowed for a adult business and where it could be located, and it was along other businesses. But we usually see it not just limiting the number of adult businesses that can be near each other. Usually in these cases, like in the Renton versus Playhouse Theater cases, those cases tend to be limiting adult businesses from being able to exist at all, or making sure that they're in a certain part of town. And so this is a regulation that normally would be content neutral, right? That it says that it can't be within a certain amount of usually space, so it can't be within 500 yards or 1,000 yards. Not necessarily saying that it's about a certain thing. This regulation is where something that's treated as content-based, such as moving something at like an adult theater or adult bookstore and making sure that it isn't around anything else. That's a content-based rule because it's subject matter based. It's also viewpoint based. So it's content-based restrictions, but gets treated as content neutral. And why is this important? Well, because as we just talked about, content-based rules, the government has to have a really compelling interest to get involved with it, and they usually lose. Whereas if it's content neutral, they only need to have a, important interest, and usually can at least manage to win. The idea behind this is that the message perceived creates more harm than good. That if you have an example of a strip club, well, that has to bring in drugs, that has to bring in violence and gangs and all sorts of seedy business. And because of that, the government's able to regulate this. Now, secondary effects doctrine only exists in the adult entertainment world. I have never seen this tested anywhere else other than for strip clubs or adult bookstores or adult theaters. Those are the only places where I have seen it actually tested. And so it's a very limited test, and it's a slippery slope, right? When do you start testing other things? But so far, it's only been held for adult theaters, adult establishments, I should say. And so because of that, it limits where adult theaters can be. So just imagine, and take this from just anywhere, right? So if I'm in an adult business and I want to establish in Valdosta, and Valdosta has a regulation that says, well, you have to be 1,000 feet away from any church or any multi-family housing place. Tell me in Valdosta where I could be. Right? There's a church at every corner. Right? It would be very hard to establish a business like that in the city unless I'm sort of on the outskirts of town or in the industrial end. And those would be kind of the places where they exist. And of course, this doesn't apply to any other business, right? The city of Valdosta can't put in a ordinance that says, dear hardware store, you have to be 1,000 feet away from any church or school or apartment complex, or whatever it is. So it only exists in this realm. And at this point, it's still law. They can still do it. I have not seen a change in secondary effects doctrine. I don't expect to see a change, but it is a caveat, kind of the asterisk, when we talk about content neutral versus content based.